Okay. So let's start with our discussion for the second quarter. So no first quarter nung midterms, ang naging topic natin for loan obligation and contracts is the first part, yung title 1, which is the obligations. Ngayon, dito tayo sa second quarter natin kung saan yung topic na is yung contracts and yung last part which is the natural obligation pero maikli lang naman yun. So let's start with title 2, contracts. So for this lecture video, dito muna tayo sa chill muna tayo dito sa first lecture video. Dito lang tayo sa chapter 1 sa general provisions. Basically, ito yung introduction part ng contract. So chill lang tayo. Yung chapter 2, yung essential requisites ata yun. Essential requisites ba yun? Yung essential requisites ng contract sa Sunday ko na i-upload. So dito muna tayo. Ito lang. So maikli lang tong first lecture video for contracts. Intro lang basically. So dito tayo ngayon sa chapter 1, general provisions. Article 1305. So, itong Article 1305, di ba? Gaya na sabi ko sa inyo nung midterms, yung definition ng obligation, yung an obligation is a juridical necessity to give to do or not to do, hindi yan mawawala sa iyong isipan. O, always mo yung maalala. Second to that is yung definition ng contract. Because ito, without reading, a contract is a meeting of minds between two persons whereby one party bounds himself with respect to the other to give something or to render some service. So, without even reading the article, I was able to provide to you the definition of a contract. Because why? Being an accounting students. Oo. Normal na yun sa inyo na mamememorize nyo. Oo. Mapafamiliarize kayo. Oo. Makakabisado yung meaning ng obligation, yung meaning ng contract. So, tiyan mo, working na ako ngayon. Di ba? Kag-graduate na, matagal na since nag-student ako, pero until now, kabisado ko pa rin yung yung definition ng contracts even without looking sa libro, di ba? So ngayon, di ba kabisado niyo na ano meaning ng obligation? Ngayon, sa contracts naman, di ba? Contracts is a meeting of mind between two persons whereby one bounds himself with respect to the other to give something or to render some service, which is the Article 1305. Yun yung definition ng contract according to the law. Di ba? Yan yung binigay na definition ng Civil Code eh. So yan ang ifa-follow natin. So ngayon, saan tayo? So, meaning pa contract, di ba napag-usapan natin? Di ba? Sa sources of obligation. Ano-ano yung 5 sources? Law. Unang-una, law. Pangalawa, obligation. Obligation contract. Quasi-delict. Quasi-contract. Tort or crimes. Di ba? Pero basically, kung i-observe natin, di ba? Parang dalawa lang talaga yung totoong sources ng obligation. Law and contracts. Bakit? Kasi yung yung quasi-delict, yung quasi-contract, yung crimes, laws, torts, di ba? Saan yan sila nanggagaling? Sino nagbigay sa kanila ng existence? Nanggaling yan sila sa batas mismo, sa law. So, kung titingnan mong maigi, dalawa lang talaga yung source ng obligation. Law and contract. And yung law, napag-usapan natin eh. Yeah? Ngayon, dito tayo sa second primary source of obligation, the contract. Yung contract. So, dito tayo meaning of contract. 1305 lays the emphasis on the meeting of minds between two contracting parties which takes place when an offer by one party is accepted by another, etc., etc. So, sabi dito, in contract, there must be at least two persons or parties, at least, so pwedeng maramihan yan. Because it is impossible for one to contract with himself. Ano yun? Para ka nang nasiraan ng bait. Kasi makipagkontrata ka sa sarili mo, di ba? Like yung dude sa Japan, if you can still remember the news na nakipagkasalan siya, he entered in a contract of marriage with himself. No? He loves himself so much, pinakasalan niya ang sarili niya. Ngayon, valid ba yung contract na yun? Kung pupunta mo sa Philippine setting, hindi. Because sabi ng batas natin, contract, as the definition itself, at least two parties meron dyan. At least two parties. Because kung hindi yan two parties, then walang kontrata. Kasi ang kontrata is a civil relationship. Kapatid, civil relationship yan. It creates a civil relationship. Sa isang relationship, di ba? At least dalawa. Kung marami na, baka bit ng iba, di ba? Ganun. Pero, kidding aside, contract creates a civil relationship between the parties. So, because it creates a relationship, from the word relation, kailangan at least dalawa sila. So ito, contract and obligation distinguish, nakalagay dito, as we have said, contract is one of the sources of obligation, while on the other hand, obligation basically pertains to a juridical tie or legal tie or relation itself that exists after a contract has been entered into. So pag na-perfect na yung contract, goods na, yeah, there's already an obligation. So ang contract, sources of obligation. Ang obligation, it is the legal tie between the parties. It creates it is the civil relationship between the parties itself. Ano tong chat na to? Saan dito yun? Contracts and agreement, ano pa Bisaya tayo dito? Contracts and agreement distinguish. So ito naman, distinguishment sa isang contract at isang agreement. So contracts are agreements enforceable through legal proceedings. So those agreements which cannot be enforced by action in the courts or of justice, just like an agreement to go to a dance party, di ba? Nag-usap kayo ng friends mo na pumunta kayo sa isang dance party pero hindi ka sumipot. Ngayon, ito kasing contract and yung agreements, di ba? Lahat ng contracts is an agreement. Bakit? Definition ng contract Contract is a meeting of minds. Ibig sabihin nagkaroon ng agreement between the parties. Kaya meeting of minds. Other term dyan, agreement. However, although all contracts are agreements, hindi lahat ng agreements are contract. Diba? Although all contracts are agreement, it does not necessarily mean na yung lahat ng agreements are kontrata. Hindi, kasi may mga ibang agreements. Gaya na sabi dito, an agreement to go to a dance party. Hindi yan kontrata, kapatid. Oo, kasunduan nyo lang yan magbabarkada. It is merely a social or moral obligation. Social or moral obligation. Hindi yan kontrata kasi agreement lang yan to go to a dance party. It is basic. Oo, it emanates from the social relationship as a member of society. As we have said, di ba, previously sa midterms, moral obligations, they are not enforceable. Moral, natural obligations, they are not enforceable. Oo. Civil obligations, they are enforceable. Yung tayo sa classifications of contract. So ito, maraming classifications na provided. The following may be mentioned. According to name or designation, madidiscuss naman to sila isa't isa. According to perfection, according to cause. Yeah? Itong according to name or designation, nominate, ibig sabihin, given. May pangalan na binigay sa kanyang batas. The contract is named by law. May example tayo, sales. Diba? May law on sales tayo. Diba? Law on sales. Law on contract of sales. Nominate, binigyan siya ng pangalan. I-nominate, mga agreements or contracts na hindi nabigyan ng pangalan. According to perfection, consensual, may discussion dito. According to cause, onerous, remunatory, gratuitous, according to form, according to obligatory force, valid, resistible. Ito itong according to obligatory force, itong valid, resistible, voidable, unenforceable, and void. Ito yung pinaka heavy discussion when it comes to contracts. Itong valid, basically itong apat na resistable, voidable, unenforceable, and void. Ito yung kung magkakaroon man ng questions about sa contract, dito yan manggagaling sa kanilang apat. Kasi intriguing to sila. Ito yung kailangan talaga ng analysis. Itong next, number 6, according to persons obliged, unilateral, bilateral. From the word itself, unilateral, isang lang, bilateral, both of them. According to dependence to another contract, meron tayong tatawag na preparatory. Ibig sabihin, the purpose of that contract is to prepare something, gaya ng agency and partnership. When it is entered into as a means to an end. Bakit tong agency? Kasi di ba, pag magpapasok kasi sa agency contract, ang kasunduan mo niya is yung agent mo magiging representation of himself for that agent to do some errands or to enter into some transactions in representation of you. So, yung agency na yan, preparatory. Kasi, nagkasunduan lang kayo para yung agent na yan magtrabaho para sa'yo. Maging representative mo. Mag-enter into the construction kaysa preparatory. Also, the contract of partnership is also preparatory. As you know, next sem, i-discuss sa inyo yung law on partnership, corporation, and cooperatives. So, baka kung maging teacher dyan. Pero para isa yan sa mga characteristics ng partnership contract, yung pagiging preparatory niya. Bakit? Kasi itong mga partners ito, nag-enter. Oo, pumasok sila sa isang kontrata, in this case, the partnership contract, because it is only preparatory in a sense na kaya sila pumasok ng partnership contract para mag-conduct ng business. Diba? To conduct business. Kaya naging preparatory yung partnership contract. Kasi yung ends talaga nila, yung goal talaga nila is to conduct a business. Diba? Kaya sa preparatory. Accessory principle, na pag-usapan natin last sem, diba? Accessory, it is dependent upon the principal. So, and as we know, accessory follows the principal. Principal, independent siya, di ba? Hindi na kailangan ng validity, yung validity and existence siya, hindi naka-base sa existence ng other contracts. Ito naman dito na sa number 8. According to risk, commutative, aleatory, according to liability, unilateral, bilateral. So, now kapatid, take note of this. Take note of this. The kind of contract entered into is not determined by its name or title given to it by the parties, but rather, yung pagiging kind niya depends on the nature or character as determined by the principle of law. So, yung kind of contract, gaya na sabi dito, ulitin na natin, hindi yan nakadepende sa kung ano yung pinangalan ng parties dyan. Oo. Nakadepende yan sa kung ano yung nature, ano yung characteristics ng contract. Kapag titingnan mo yung contract, yeah? Kung ano yung nakikita mo, ano yung based sa facts and circumstances in relation to that contract. Like for example, di ba? Ikaw, kaibigan mo, ikaw, di ba? You, crush mo, friend mo, binigyan ka, nagbentahan kayo, di ba? Kunwari, pumasok kayo sa contract of sale, di ba? Kunwari, pumasok kayo sa contract of sale kung saan yung binigay niya is kotse, and yung binayaran mo is 1 million. Ngayon, at first glance, and as the name provided by the parties, this is a contract of sale. However, when looking into the nature, the characteristics of the contract, makikita mo is, bakit may interest, di ba? Kita mo yung usapan nila, bakit may payment of interest of 12% per annum? Eh, di ba? Contract of sale to. Bakit may payment of 12% interest per annum? Ano yan? Anong reason yan? Ngayon, di ba? Titingnan mo talaga yung contract. Aba, mukhang hindi to contract of sale. Mukhang contract of loan to. Kung saan yung car naging collateral. Yeah? Kung saan yung car naging collateral. Yeah? Kasi sa mga, natitingnan nyo, di ba? Parang ganun. Naging collateral ng contract. May provision pa dyan may stipulation pa sa kanilang agreement na pag hindi na, pag at the end of the contract or at the end of the term period provided in the contract, isa sa uli ni C yung isa sa uli, tag dito. Wait lang, tayo tubig. Ganyan. Basically, ganun yung G's yan eh. Just because sinabi ng parties na, uy, contract of sale to. Hindi. Huwag kayo maniwala agad. Tingnan nyo yung, tawag dito. Tingnan nyo yung nature and characteristics. Another example. Bigyan pa tayo ng another example. Yeah? Ito to, bahay. Diba? Kunwari si buyer to. Ito si seller. Ngayon, nagbentahan sila ng bahay. Kung saan ang binigay ni buyer, pambayad niya is 100K. 100K to. Tapos itong binigay ni seller, di ba? Yung binenta niya, house and lot. Ngayon, ang binigay nilang pangalan sa contract is, it is a contract of sale. Real property sale. Pero titingnan mo yung contract mismo, yung nature and characteristics niya, nagtataka ka. Chicken, house and lot yan, bakit 100K? Tapos, yung property na yan doon sa affluent areas, tapos 100K lang ibibenta? Di ba? Mag-isip ka na. So, in this case, di ba kahit na sale, ang binigay na pangalan sa contract na yan, Pero based on the nature and characteristics of the contract itself, masasabi mo na, uy, mukhang hindi to contract of sale, but rather a donation. O kasi house and lot na binenta kung saan yung property na yun is located in an affluent area na kung saan mamahalin yung mga adjoining properties tapos 100 lang binibenta, magtaka ka na. So in this case, since 100k lang yan, so ang masasabi natin dyan is that is a donation, a contract of donation. Donation yan. O di ba? Mga ganong analysis, kapatid. Ngayon, let's go to Article 1306. So, Article 1306 provides that the contracting parties may establish such stipulations, clauses, terms, and conditions as they may deem convenient. So, provided they are not contrary to lamok, PAPS, law, morals, good customs, public order, and public policy. So, anong masasabi natin dito? Ewan. So, ito, basically, anong sinasabi ni 1306? Freedom, etong general rule. Freedom of contract, freedom to enter into contract, or freedom to contract guaranteed. So, the right to enter into contract is one of the liberties guaranteed for the individual by the Constitution. But take note, that is the general rule. And as we have said, for every general rule, there's always an exception. Anong exception yun? Police power of the state. Police power of the state. Wala pa siguro kayong taxation yan, no? Pero as you know, sa taxation, sa general principles of taxation, isa yan sa mga pag-uusapan nyo is yung inherent power of the state. O, pag-uusapan yan, inherent power of the state. And little intro lang, dagdag chika-chika lang dito sa discussion natin. May tatlong inherent power yung state. Yung state, yeah? Yung not necessarily the country, but the state itself, yeah? Parang United States, yung state. Yung Philippines, state. Yeah, ganon. Kasi may mga distinguishment yan eh. Pero get nyo naman idea kung ano yung state. Ngayon, itong state, diba, may tatlong inherent powers yan. Ano-ano yon? Ito, konting ito lang. Parang additional knowledge lang to sa inyo. Una is yung police power. Pangalawa is the power of taxation. Pangatlo is the power of eminent domain. Ngayon, ito yung chika bells dito. Yung state may three inherent powers. Police power, taxation, and eminent domain. Ngayon dito tayo sa taxation. Anong sense niyan kumbaga? Taxation is basically, di ba? Magbabayad ka ng tax sa government, di ba? Explain natin to in layman's term. Di natin kailangan mag-in-depth dito. O, taxation. Anong essence niyan? Basically, as a member of the society, di ba? That enjoys the protection given by the government, you are obliged, you have an obligation to give your contribution for that protection. Yeah? You give a portion of your earnings to the government kung saan yung government gagamitin yung contributions na yon, yeah, to make sure that the society is secured, is properly governed. So yan, di ba? Mutual relationship yan. You give your tax to the government will use that tax to make sure that the society is properly regulated, properly governed. That's the power of taxation. So, lifeblood yan ng government. Kung saan, kapag walang taxation, walang ng contribution, di ba? Walang magko-contribute sa funds para magtrabaho yung government, the government will be paralyzed. That is the importance of taxation. Di ba? You are a people that enjoys the protection given by the government, whether you feel it or not. Yeah? Because we're talking about the principle. Whether you feel it or not, being the member of the society in which that government governs, you are obliged to give your contribution. Yeah? In order for the government to continue governing or regulating, di ba? Making sure that the society is safe. That is taxation. dito tayo sa eminent domain. Ano tong eminent domain? Other word dito na ginagamit is expropriation, whereby the government takes over or acquires private property. Kung saan yung private property na yan gagamitin for public use. But take note, it can only be done through payment of just compensation by the government to the owner of that private property. Yan yung eminent domain. Kaya may nakita kayo, di ba? Yung mga nood kayo news, yung mga right of way, di ba? Right of way. Na kung saan, before makapagpatayo ng kalsada dyan yung government, kailangan muna nilang bilhin yung lupa. Di ba? Kailangan muna nilang bilhin yung lupa kung saan nila itatayo yung kalsada. Ngayon, tatayo, sir, pwede mo bang i-deny yan na magpakipot ka sa government na ayaw mo ibigay yung lupa mo? Hindi pwede, kapatid. Oo. Kapag yung at first, nag-negotiation kayo, tinanggihan mo yung offer nila, pwede silang pumunta ng korte, pwede ka nilang i-compel na ibenta yan. But of course, upon payment of just compensation sa'yo. That is the power of the government. The government can do that. You cannot deny. Mahirapan kang i-deny yung power ng government na yan. Oo. Your only defense to that is make sure na ipa-explain sa government na for public use talaga yan. Pero pag mga kalsada, di ba? Automatic public use yan. Di ba? So, mahirapan ka nang i-defend yan. So, basically, nangyayari dyan is napapahaba yung process. Pero in the end, most of the cases, wala kang choice. Ibebenta mo talaga yung property mo sa government. And lastly, ito na yung sinasabi nating limitations to the freedom of contract. Police power. Ngayon, pagdating nyo sa taxation nyo, merong qualities yung police power na wala yung taxation and eminent domain. Ano yun? The power to impair contracts. Oo. Pwedeng i-chapwera yan ni police power yung contracts, yung taxation, yung eminent domain. Wala. Hindi nila pwedeng i-chapwera yung contracts. But the police power, kasi sa dito sa meron tayong clause sa Constitution na non-impairment clause tatawag. Ibig sabihin, hindi mo pwedeng bastang i-chapwera, baliwalain yung mga contracts kahit si government. Bawal niya yan baliwalain. However, that is the general rule. Because nandyan si police power eh. The police power ignores the non-impairment clause of contracts. The police power can impair contracts. Pwede niyang i-chapwera yan. Pwede niyang baliwalain yan. Bakit, sir? Ano nga ba tong police power? Police power, basically, in layman's term, is the protection given by the state in order to secure the general welfare of society. That is the police power. Di ba? That is the police power. Yung perang nakukuha nyo dito sa taxation, ginagamit niya yan sa implementation ng police power. And because we're talking about the general welfare of society, it can be used by the state, the government, as a reason to impair contracts, as a reason to take someone's liberty away. Di ba? Di ba? Meron tayong right to privacy. Meron tayong tinatawag na right to privacy. Meron tayong tinatawag na right to our property. But when the government properly implements police power, the government can, i-chapwera nila yang rights mo. Bakit? General welfare. This is for the general welfare of society. Di ba? Di ba? Yung mga yan yung di ba, yung sa anti-terror law. Ito. Di ba, yung sa anti-terror law na pinag-aawayan nila. Ito yung ito yung magiging primary weapon ni Solgen, police power. Kailangan nilang patunayan na yung threat of terrorism very prevalent. Kaya kailangan nila ng additional weaponry o additional mechanism in order to combat that. Because that is for the general welfare of society. Police power is very, very strong. Now in this case, di ba, napag-uusapan natin yan. Gabi ang sidestep natin. Yes, you have the freedom to enter into contracts, to give any stipulations you want. But take note, police power, kapatid. Hindi pwedeng talunin yan ng police power. Ichapwera yan. Nakalagay dito, in appropriate cases, it cannot be invoked as against the right of state to exercise its police power. Wala kang choice. Continue tayong discussion natin. However, because the freedom of contract is both a constitutional and statutory right, to uphold the right, courts are enjoined to move the necessary caution and prudence in holding contracts void, etc., etc. Dito tayo ngayon sa next, limitations on contractual stipulations. Di ba? Provided dito, diba, sabi ni Article 1306, meron kang freedom. Meron kang freedom to enter into contracts. However, it should not be contrary to lamok paps. And as you have said, sa midterms pa lang, what is lamok paps? Law, moral, good customs, public order, public policy. So there are limitations to the freedom of contract. Law, it is a fundamental requirement that the contract entered into must be in accordance with and not repugnant to an applicable statute. Meaning lang yan, kapag may conflict sa law, may conflict sa contract, anong masusunod? Batas. Law ang masusunod. The law sets the limits to what you can do in your contract. Hence, the general rule, freedom to contract. Exception, must not be contrary to lamok paps. Tatanungin yan. Tatanungin yan. Anong nagbibigay? And the second limitation to the power of the contract is the police power. Gaya sabi dito, when there is no law in existence or when the law is silent, the will of the parties prevail unless their contract contravenes the limitations of good morals or morals, good customs, public order, or public policy. Basically, it implies to the reservation of the power of the state to exercise its police power. And ito, may explanation dito. Yung explanation ng lamok paps, inulit lang. So, contract, law, di ba? As defined is the napag-usapan natin, ito yung first discussion natin. A rule of conduct, just, obligatory, promulgated by legitimate authority and a common observance of law, etc., 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 etc. na lang to. Contracts must not be contrary to morals, and as we know, morals is, or it deals with norms of good and right conduct evolved in a community. Itong good customs are the habits and practices which, through long usage, have been followed and enforced by society or some part of its binding rules or conduct. Now, minsan, nag-overlap talaga itong si morals pati si good customs. Nag-overlap siya, di ba? Medyo nahirapan tayong i-distinguish silang dalawa. Kasi nag-overlap sila eh. But basically, di ba, pagkunan natin yung natutunan natin sa philosophy natin, di ba? Or sa religious, kung may religious subjects man kayo, di ba? RS, Religious Studies. Morals is basically kung ano yung dictation sa'yo ng iyong konsensya, of your conscience. Yung good customs, di ba? Basically kung ano yung culture, ano yung practices within the area. So yun yung nagdi-distinguish sa good customs and sa morals. Di ba? Dito naman sa public order refers principally to public safety, although it has been considered to mean also the public will, public policy, etc. Let's go to Article 1307. Now, Article 1307 talks about the innominate contracts. So, sabi ni 1307, innominate contracts shall be regulated by the stipulations of the parties, by the provisions of Titles 1 and 2 of this book, by the rules governing the most analogous. Analogous, ibig mo. Analogous nominate contracts and by the analogous nominate contracts, ibig sabihin yung mga nominate contract siya. May pangalan na binigay sa kanya yung batas. However, it is very analogous or mahirap i-gets. Diba? Magulo yung kanyang characteristics. And by the customs of the place. So, yan yung mag-govern or mag-regulate sa innominate contracts. Provided naman, ano yun? Stipulation of the parties. Sabi ni Title 1 and Title 2 ng book na to, which is obligations and contracts. By the rules governing the most analogous nominate contracts, pangatlo, and by the customs of the place. So, kung anong sinusunod sa lugar nila. So, to classifications of contracts according to name, na-mention naman natin to. Yung una is yung nominate contract. Ibig sabihin, there's a specific name or designation that is given to them by the law. For example, commodatum, law on leases, agency. Itong agency, sa third law subject siya to matitake, second year, second semester. Kasi second year nyo, pag second year nyo, ang una nyong ititake will be, ang unang law subject yung ititake will be law on partnership, corporations, and cooperatives. Baka ako maging teacher nyo dyan kasi ako nagturo last sem. Ito, another nominate contract, yung law on sales. Ito, third law subject na rin to. And yung second, as we have said, as provided by 1307, is a nominate contract kung saan walang specific name or designation na binigay sa kanya yung batas. And there are 4 kinds of nominate contracts. Do ut des, I give that you may give. Do ut facias, I give that you may do. Facio ut des, I do that you may give. Facio ut facias, I do what you may do. So basically parang ano to eh. Yung do ut des no, hindi na siya i-nominate contract. Bakit? Kasi tingnan mo ang do ut des. I give that you may give. May ibibigay ako sa iyo kung saan in exchange may ibibigay ka sa akin. Di ba familiar? Ano 'yun? Barter. Meron naman tayong barter. And yung barter natin under siya sa law on sales. So, since may pangalan na siya, barter na siya. Yung do ut des, yung I give that you may give, wala na yan. 'Di ba? Ito. Yung isa, I give that you may do. So, may ibibigay ako, may gagawin ka. So, di ba? Real obligation, personal obligation marireceive mo. Facio ut des, I do that you may give. O, ito naman, ako may gagawin, personal obligation to do. May marireceive akong real obligation. I do that you may do. Ito naman, personal obligation, palitan sila. Okay. So, anong reason ng in-nominate contract? Basically, simple lang. Trying to nominate every forms of contract that is possible or that can happen is very hard. Hindi mo pwede lahat ng posibleng mangyaring kontrata na maisip ng mga tao, mahihirapan kang bigyan ng pangalan yan lahat. Yeah? Mahirapan kang bigyan ng pangalan lahat. So, in that case, ang gagawin mo na lang, yung mga major contracts na pwedeng mangyari, na frequent nangyayari, yun na lang ang bigyan mo pangalan. Yung mga minor lang naman, okay. Bigyan mo na lang ng category na being an in-nominate contract para madali yung buhay. Oh. The impossibility of anticipating all forms of agreement on one hand and the progress of man's sociological and economic relationships on the other hand justifies this provision. Kasi mahirap i-anticipate lahat ng possible contracts na pwedeng maisip ng tao. So, yung mga major na lang, yung mga frequent na nangyayari, yun na lang, gaya na sabi natin, bigyan mo ng pangalan. Para pa din. Tapos yung mga hindi mabigyan ng pangalan, categorize mo na lang siya. Bigyan mo lang siya ng category of being in-nominate. Pero, don't discredit it. Valid pa rin sila sa batas as long as hindi nila nilalabag yung lamok paps. So ito, rules on governing in-nominate contracts, the agreement of the parties, the provisions of the civil code on obligation contracts, ito na yung nakalagay sa 1307, the rules governing the most analogous contracts, and the customs of the place. So Article 1308, the contract must bind both contracting parties. Its validity or compliance cannot be left to the will of one of the parties. Na ito. Basically, this is a restriction when it comes to contracts. Yung una, it must bind the contracting parties, meaning dapat yung part niyan, sila, tawag dito, magiging obliged sila, kumbaga. It should bind both of them. It should oblige the parties sa kontrata. Kailangan silang maging obligated sa kontratang yan. So, its validity or compliance cannot be left to the will of one of the contracting parties, di ba? Kasi napag-usapan natin to sa previous midterm, di ba? Meron tayong tinatawag na protestative conditions kung saan the conditions is left to the will of one of the contracting parties. Now, in this case, yung pagiging protestative dito, in terms of the compliance and validity, hindi pwede. Hindi pwede kasi magiging unfair yan sa kabilang party na kung saan yung validity compliance nakadepende lang sa isang party. Yung other party, ano mangyari doon? He is at the mercy of the party who has the will to validate or comply with the contract. He will be left to the mercy of the other party. Hindi naman pwede yan. Napaka-unfair, di ba? Oo. So, contract binds both contracting parties. A contract is an agreement which gives rise to obligations. It must bind both parties in order that it can be enforced against either. without this equality between the parties, it cannot be said that the contract has the force of law between them. Yun, isa rin sa mga reasons. Di ba? Kailangan binding yan sa both parties para yung both parties maging obligated sa kanilang obligation na pinasok sa contract para yung force of law ma-properly implement dyan. So, it is fundamental rule that no party can renounce or violate the law of the contracts without the consent of the other party. So, di ba? Like for example, meron kayong kasunduan na magpapalitan kayo ng magpapalitan kayo ng kotse ng kaibigan mo. Nag-enter kayo sa contract. Ngayon, yung palitan ng kotse na yun, bigla ka nag-back out. Ngayon, valid ba yun? Depende. Kapag nag-agree, binigay ng kaibigan mo yung kanyang consent sa pag-back out mo, edi goods. Pero kapag hindi siya nag-agree, mahirap na. Di ba? Mahirap. Kasi, hindi siya nag-agree. Gusto niya yung kotse mo. Kaya gusto niya talagang ituloy yung kontrata nyo. Problema, ayaw mo, nag-back out ka sa kasunduan nyo. Yun. Kung gusto niya talaga, mag-file yun sa'yo ng kaso. O, civil suit, kumbaga. So, yun, di ba? So, pag kailangan ng i-renounce ng party, ayaw na ng party sa kontrata, gusto niya mag-back out, renounce tawag doon. Oo. Hindi niya pwedeng gawin yun nang walang consent ng the other party. Because the contract must be binding on the both of them. So example, S agreed to sell his car to B for 100,000 pesos. The contract is binding upon both contracting parties and either of them can enforce the contract against the other. So yan. So tuloy lang natin itong basahin ng example na to. A stipulation in the contract to the effect that the contract shall be considered invalid if so declared by S, or that S can comply with his obligations if he wants without the same privilege given to B, then yung kontrata na yun will be considered as void. O bakit? Di ba? Gaya na sabi natin. Validity and compliance cannot be left to the will of one of the contracting parties. Ngayon, nakalagay dito, si S, choice niya kung gusto niya maging valid or invalid ang contract. Choice niya kung magko-comply sa contract or hindi. While that privilege is not given to B. Baka kawawa naman si B. The performance of the contract, the fulfillment of the contract is left to the will of S. Naging potestative. Kawawa si B. He is at the mercy of S complying and making the contract valid. Yeah? Anong iisip natin? Unfair. So sabi ni 1308, bawal yan kapatid. Dapat fair tayo. So let's go to Article 1309. The determination of the performance may be left to a third person whose decision shall not be binding until it has been made known to both the contracting parties. So ito, ang general rule kasi, yung third persons bawal umepal. Yan yung ano natin eh. Yan yung general rule diyan pagdating sa contracts sa mga parties. Ang mga third persons bawal umepal because the contract is between the parties who entered into that contract at the first place. So yung mga third parties, yung mga kabit, huwag kayong mag-epal. However, may mga certain instances na kung saan yung mga third parties pwedeng makisali. Ito yung isa sa mga ito na yung isa sa mga circumstances na pwedeng mag-epal yung third party. The determination of the performance may be left to a third person whose decision shall not be binding until it has been made known to both contracting parties. So ito. Under the preceding article, compliance with the contract cannot be left to the will of the contracting parties. Bawal yun. Di ba? Yung validity and compliance left to the will of the contracting party. Yung pagiging potestative, basically, bawal. Kasi unfair sa other party. However, as provided under Article 1309, the determination of its performance may be left to a third person. In such case, the obligation does not depend upon a potestative condition but rather at a casual condition. Diba? Napag-usapan natin yan sa condition, diba? Meron tayong casual kung saan the condition is left at the will of the third party. Meron tayong potestative kung saan yung condition is left at the will of one of the contracting parties. Meron din tayong tatawag na mix, diba? Kung saan partly upon chance, partly upon the third party. Yeah? Ngayon, potestative, dito, pinag-usapan natin, bawal. Yung casual, upon the will of the third party, goods lang. The decision, however, shall bind the parties only after it has been made to both of them. So ito, sinasabi dito, before maging binding, yung determination na sinabi ng third persons, dapat may notice, dapat aware, of course, yung original parties na, ay, okay, good yan sa akin. Yeah? Kailangan bigyan sila ng notice. Like for example ito, yeah? Benta ka ng lupa. Ngayon, yung price ng lupa na yan, medyo mahirap yan i-appraise. Mahirap i-assess yan. So, kayong seller buyer, pupunta kayo sa isang appraiser para para kunin niyo yung service niya, para i-assess yung value ng lupa na magiging subject ng sale between the two of you. So yun, in that case, si appraiser, siya? Third party. Yeah? Diba third party si appraiser? Kasi ito lang yung kontrata eh. Pero si appraiser, since kailangan nyo ni buyer and seller na malaman kung ano yung value ng lupa, punta kayo sa appraiser, hingin yung service niya, para yung appraiser, bibigyan niya ng value yung lupa. Like sabi niya, itong lupa na to, it is worth 1.5 million peso. O yun. Yeah? Binigay ni third person, the appraiser, yung kanyang yung kanyang notice na yung lupa is worth 1.5 million. That is the determination of the performance left to the third person. And notice was given to the party. So yan, an example of 1309. So 1310, the determination shall not be obligatory if it is evidently inequitable. In such case, the court shall decide what is inequitable under the circumstances. So, when the determination made by the third person is inequitable, unconscionable, kumbaga unfair, basically in layman's term, then in that case, punta kayo sa korte. O, di ba? Basically, sinabi ni appraiser, itong lupa na to, kahit located sa Green Hills, it is only worth 100K. Ikaw seller, kalokohan ka naman seller, 100K na sa Green Hills ang located. Di ba? Bahala ka. Punta tayo sa korte buyer, doon korte na magdi-decide magkano to. O, yun. Kapag inequitable, kapag unconscionable, basically kapag unfair. Di ba? Punta tayo sa korte. 1311. So, mahabang 1311. Contracts take effect only between the parties, their assigns and heirs, except in case where the rights and obligations arising from the contract are not transmissible by their nature or by stipulations or by provision of law. The heir is not liable beyond the value of the property he received from the decedent. Decedent meaning yung namatay. Yeah? If a contract should contain some stipulation in favor of a third person, he may demand its fulfillment, provided he communicated his acceptance to the obligor before its revocation. A mere incidental benefit or interest of a person is not sufficient. The contracting parties must have clearly and deliberately conferred a favor upon a third person. So basically, itong 1311, dalawa yung kanyang discussion. Una is yung, sa first paragraph niya is the transmissibility of the rights and obligations in a contract. Yung sa second paragraph niya, kung saan, it talks about the stipulation for atruy, di ba? A stipulation na contract which favors the third person. So, dito muna tayo sa first paragraph, yung sa transmissibility. So, ang general rule, as you have said, napag-usapan natin to sa di ba? Sa last part ng discussion sa obligation, yeah? Yung transmissibility of rights. Last part ba yun? Ito meron tayo pagbasa sa part of last discussion yun. Yung transmissibility of rights. Payment of performance, loss of the thing due, Saan ko ba yung nasabi? Saan ko yung nasulat? Basta meron tayo na pag-usapan, di ba, yung transmissibility of rights. Diba? Anyways, na-discuss naman yun. Pero dito lang, focus tayo dito sa 1311. So, general rule, yeah, a party's rights and obligations derived from the contract are transmissible to the successors. Meaning, pwede mong ipasa yung rights and obligations mo. May transferability siya. However, that is the general rule. May exceptions tayo. Like for example, Wendy, mayroon naman discussion dito, di ba? Dito naman yung discussion yung exceptions. So, under 1311, contracts takes effect only between the parties, their assigns, and their heirs. So, this means that only the parties, their assigns, and heirs can have the rights and obligations in the contract. Yeah? Like for example, ito may example tayo dito. D is indebted to C. D is indebted to C. Ngayon, in the amount of 10K. Ito may clarification discussion dito. Kasi iba yung wording na ginamit ng book eh. So, si D may utang kay C of 10,000 pesos. Ngayon, ito yung kontrata. However, later on, namatay si D. Dedo siya. Ngayon, itong si D, meron siyang heir. Diba? Si H. Si H, sa yung, okay, wait lang. Sa yung heir ni D. Ngayon, obligated pa rin bang bayaran yung 10K kay C? Kahit na namatay na yung original debtor? Kahit na namatay na yung original debtor? Yes, obligated pa rin bayaran yan. However, ang sinasabi kasi ng book dito is, ngayon si H na yung bound na bayaran yung 10K kay D. Ang problema kasi dyan, mali yung wording. Bakit? Malalaman sa taxation na once may namatay, itong properties ang namatay na to, napupunta sa kanyang estate. And ang estate is a juridical personality. Oo, is a juridical person that has its own personality. Oo, juridical person yan. A personality that is created by law. It is artificial, it is not natural. So, mali yung wording na ginamit dito. Kasi once na namatay ito si D, yung kanyang utang mapupunta sa kanyang estate, yung kanyang properties mapupunta sa kanyang estate. Na kung saan, yung estate na yan, estate tawag natin dyan, yung mga utang ni D nung buhay pa siya, dito kukunin yung pambayad. And kung anong matira, kung anong matira sa estate na yan, yan na yung i-contribute sa kanyang mga heirs, sa kanyang asawa, sa kanyang mga anak, sino may nilagay niya sa will niya, yeah? Yan yung proper na nangyayari. Pero ang sinabi dito, pag namatay si D, yung anak niya, yung heir niya, siya yung magbabayad ng 10K kay C. Pero gaya na natin yun. So, continue with the discussion. Pero ito talagang totoong nangyayari. Oo. Ito talagang totoong nangyayari. Namatay siya, may estate siya, yung estate yung magbabayad. Oo. The most that can happen is yung si H yung mamanage ng estate. Siya yung magiging executor, magiging administrator ng estate. So, yan yung sa tax yan, i-discuss sa inyo. Pero sa business and transfer tax na yun, sa tax 2 na yan eh. Mm-hmm. But anyways, continue our discussion with this one. So, ito, continue natin, di ba? Estate, no? So, let's say, for example, to continue natin discussion. Di ba? Now, in this case, ang nangyari, nung namatay si D, yung kanyang property na lang is around 7K. 7K na lang yung kanyang property. Anong mangyayari? Eh, di yung 7K yung papabayad, na sir, kawawa naman si C. Pwede niya bang kunin sa heir ni D yung remaining 3K balance? Hindi pwede, kapatid. Hindi pwede. O, di ba? Hindi pwede. O, di ba? Si D, nung namatay, may 7K na lang siya natira, so, yun yung papamana sa anak niya. Kaso, yung utang niya kay C is 10K. Na ang problema, 10K ang utang, 7K na lang natitira. Yeah? Pwede bang kunin yung remaining balance of 3K sa heirs ni D? Hindi. Hindi pwede. Hindi yung pwede. Kung ilan lang yung na-receive, kung ilan lang yung pwedeng bayaran, ilan lang kung magkano lang yung na-benefit ni H, di ba? Yun lang yung ibabayad. Kung it's a state, kung 7 ka na, di yun lang. Hindi na pwedeng maghabol si C. So, yun yung limitations. Ngayon, pag si C naman yung namatay, tapos may heir siya, then si D, ibabayad niya kay heir ni C yung utang niya kay C pag namatay si C. Parang ganun, di ba? Pasahan ng utang. However, this transmissibility of rights and obligations sa contract is only a general rule. May exceptions tayo. And ano yung exceptions na yun? Ito. The cases when a contract are effective only between the parties are when the rights and obligations arising from the contracts are not transmissible. For example, by their nature, like a contract involving personal qualifications, such as painting, singing. Like for example, di ba? Ang kontrata, si Sarah Geronimo magkakanta sa iyong birthday party. So, yun, personal obligation yun. And yung naging reason bakit si Sarah, because of her personal qualification. Kasi si Sarah Geronimo. Diba ganun? However, buyag-buyag, namatay si Sarah. And si Sarah at that time may anak. So yung anak niya, heir yun. Ngayon, in that case, yung obligation ba ni Sarah na kumanta sa kasal mo, transmissible ba yun sa anak niya na heir niya? Hindi. Because the personal qualification that made you enter into that contract was the person who will sing in your, who will sing in your birthday is Sarah Geronimo. That personal qualification itself, hindi yan napapasa sa kanyang anak. Yeah? So in that case, it is not, the rights and obligations is not transmissible. Hindi mo pwedeng ipasa sa anak ni Sarah yung obligation ni Sarah Geronimo. Yeah, ganun. Na kumanta sa kasal or party nyo. The second exception is by stipulation. Kapag kahit na transmissible yung contract, pero kahit na in essence, transmissible, possible yung transmissibility ng rights and obligations sa contract. Pero kayo na mismo ng parties, nilagay, stipulated na the rights and obligations in this contract is not transmissible. O yan, by stipulation. Kasi kayo na mismo ng parties sa contract na yan, nag-agree, na hindi transmissible yung mga rights and obligations yan. And lastly, by provision of law. Gaya ng mga intransmissible, agency, partnership, comodatum, when death extinguish the legal relationship, ano pa? So, cases, ito naman tayo, yan yung sa yan yung unang discussion sa 1311, sa transmissibility. General rule, ulitin na natin, transmissible. Rights and obligations na contract is transmissible. However, may exceptions. By their nature, by stipulation of the parties, and by the law. Yun yung tatlong exceptions sa transmissibility ng rights and obligations in a contract. Ito naman yung second paragraph ng 1311 talks about the favorable stipulation ng contract to a third party, na third person. And as we have said, a third person, epal to siya sa contract, outside party to siya. Is one who has not taken part in a contract and is therefore a stranger to the contract. As a general rule, ang third person, wala siyang rights and obligations under a contract. However, as we have said, may mga instances when a third party or a third person pwede siyang umepal sa contract. There are instances, na-mention natin yung una, di ba? Yung, ano ba yung una nating na-mention? Yung 1309, di ba? In that case, pwede siyang umepal sa contract because his determination, because the determination of the performance of the, of the contract may be left to a third person. Ito pa, sa 1310, 1311 provides additional more. There are cases, however, when third persons may be affected by a contract. Among such cases are the following. In contracts containing a stipulation in favor of a third person, also known as the stipulation for attrui, ibig sabihin, kahit na third person siya, favorable sa kanya yung, may stipulation sa contract na favorable sa kanya. Yes, kaya stipulation for attrui. Pangalawa, in contract creating real rights. And as we know, di ba, na-discuss natin sa obligation, real rights are what? Real rights are enforceable against the whole world. Whole world, yeah? It is binding and enforceable against the whole world. Kasi di ba, ang personal obligation, ang personal rights, it is only between the parties. Yeah, between the parties lang yan. Pero ang real contract or real rights, I mean, enforceable and binding upon the whole world. A whole new world. Pangatlo is contracts entered into to defraud creditors. Ito, napag-usapan natin to. Yung for the protection of the protection of creditors, and yung pangapat is in contracts which have been violated at the inducement of a third person. So sa una tayo sa stipulation for attorney, take note, may mga certain instances or may mga certain things to take note in stipulation for attorney para maging considered siya sa valid stipulation for attorney. So, stipulation for attorney is stipulation na contract that clearly and deliberately conferring a favor upon a third person who has a right to demand its fulfillment, provided he communicated his acceptance to the obligor before its revocation by the obligee or the original parties. May explanation pala sunod-sunod. Nakalimutan ko. Goods. May explanation pala sunod-sunod. May explanation sunod-sunod yung mga mga tawag dito. Good. So, I mean, tawag dito. So, yun yung stipulation for attorney. Ito na means, di ba? Example. Ano ba maganda example dito? Ano ba yun? Meron talaga maganda example dito eh. Ikaw, si A, dinonate yung lupa niya kay B. O, dinonate yung lupa, land, donate. However, isa sa mga yun yung contract nila, di ba? Donation of land. However, isa sa mga stipulation sa kanilang kontrata is that si C, being a squatter in that land, kung saan kaibigan niya si A, isa sa mga stipulation sa contract nila is that for 5 years, etong si C, 5 years etong si C, dapat hindi siya pwedeng galawin ni B. Hindi yung makaibang galawin. Hindi siya pwedeng paalisin ni B. Hindi siya pwedeng paalisin ni B sa lupa na dinonate ni A kay B. So, yun yung kontrata. Yung main contract, is that si A dinonate yung lupa or let's say binenta, same lang naman yun eh. Same yung magiging effect dito. Not necessarily same yung contract of sales at donate. I mean yung effect nito sa stipulation for attorney, yun ang minimin ko. Let's say, land either binenta or dinonate ni A kay B, yun yung main contract. However, there's a stipulation in the contract whereby it states that C, being a squatter, not a squatter, but being an informal settler that resides in said property shall not be disturbed for 5 years, whose possession or whose inhabitation should not be disturbed for 5 years. So that in that case, kahit na si C, informal settler, pero kaibigan niya si A, so may favorable stipulation sa contract sa kanya na for 5 years hindi siya pwedeng galawin, hindi siya pwedeng palisin, hindi pwedeng i-disturb yung kanyang inhabitation sa properly. Now, that is a valid stipulation for attorney if C will communicate his acceptance to the obligor before its revocation by the obligee or the original party. So, yun na. Sinabi, C, ito kontrata namin itong kontrata ni A and B. Kung saan, matatransfer yung ownership kay B, but don't worry, C, huwag ka mag-alala C, kasi for 5 years, hindi ka nilang pwedeng palisin. Ngayon C, tatanungin ka namin, acceptance ba? Tatanggapin mo ba tong stipulation na to or hindi? Si, sabi niya, 5 years, hindi ako gagalawin dito. Sige, tanggapin ko yan. O yun, dapat i-communicate niya. Kasi pag hindi niya i-communicate, tapos na-revoke, hindi niya pwedeng habuli. Hindi niya pwedeng sabi niyo sa contract niyo, papatirahin niyo ko ng 5 years without disturbance. Sabi ng mga parties, loko ka pala eh. Hindi ka nagbigay ng notification of acceptance sa amin eh. Yun, nagsawa kami maghintay sa'yo, revoke na lang namin. O kasalanan ni C. So, take note, para maging valid yung yung stipulation, yung favorable stipulation na sa third party, dapat may acceptance. Notice of acceptance communicated by that third party to the parties. So, yan ang stipulation for A2E. Classes for A2E, requisites ng stipulation for A2E. Ito mga requisites lang. The contracting parties by their unang requisite, the contracting parties by their stipulation must have clearly and deliberately conferred a favor upon third person. Ito, klarong-klaro, di ba? Parte ng kanilang usapan, parte ng kanilang contract is yung 5 years na hindi pwede galawin si C. Dapat klaro ha, hindi lang yung sidestep, dapat stipulated talaga and expressly sa contract yung favorable condition sa isang third party. The second requisites, the third person must have communicated his acceptance to the obligor before revocation by the obligor or the party. So yan, second requisites, kailangan niya communicate before revocation. Kasi kawawa yan siya eh. Kapag hindi niya kinommunicate before revocation, hindi niya pwedeng habulin. Kasi, ang maganda dyan, kapag na-communicate niya, before ma-revocate, acceptance yan ha, pwede nyo, kahit na third party yan siya, pwede niyang i-assert yung right niya. Oo, yung stipulation na yan, pwede niyang assert. So, for example, di ba? Si B, after 2 years, gusto nang palisin si C. Hindi pwede yun. Hindi pwede yun. Bakit? Kasi ang kasunduan sa kontrata, hindi pwedeng galawin yung inhabitation ni C for 5 years. So, pag ginawa yun ni B, pwede siyang kasuhan ni C na, uy, sabi sa kontrata 5 years, 2 years pa lang, di mo pwedeng palisin. Boom. Civil suit, pwede yun. Kaya mahalaga yung acceptance para meron kang ground pag nagkaroon ng kasuhan na. Para you can properly defend your rights. Pangatlong requisites, the stipulation in favor of the third person should be part, not the whole of the contract, obviously. Because this is the primary contract eh. Yeah? Additional lang yun, supplementary lang kumbaga yan. O supporting lang yan yung favorable stipulation kasi hindi yan yung pwede maging primary contract kasi nga mawawalan yung essence ng stipulation for A2E. Kasi stipulation for A2E dapat may third person dyan. Pangapat, the favorable stipulation should not be conditioned or compensated by any kind or obligation. So, ibig sabihin, dapat gratuitous yung stipulation for A2E. And pangapat, neither of the contracting parties bears a legal representation or authorization of the third party for otherwise the rules or an agency will apply. So, as you can see, ito klaro-klaro, di ba? Klarong-klaro. Stipulation for A2E, klarong-klaro. May kontrata, kung saan expressly provided sa kontrata na yun, na yung informal settler na si C, hindi pwedeng palisin for 5 years. Stipulation for A2E, na kung saan si C, kinommunicate niya sa parties yung kanyang acceptance. So yun. Ngayon, di ba ang sabi dito, dapat klarong-klaro sa contract na tawag ito, klarong-klaro sa contract na meron talagang stipulation for A2E, na meron talagang third person na mabe-benefit. Ngayon, may mga kontrata yan. Gaya ng example dito, na kung saan si X, magbebentahan sila ng lupa ni SM, etong lupa na yon, kung saan adjoining that lot is a property of Z. Yeah? Ngayon, pag nagpatayo ng lupa dyan si SM, alam nyo nang mangyayari, tataas yung value ng lupa ni Z. So that is favorable to Z. Yeah? Good siya sa kanya. However, itong usapan ni X at ni M, hindi natuloy. Yung usapan nila magbentahan ng lupa, hindi natuloy, nag-green out, di ba? May kontrata na sila, kaso nag-back out sila sa contract nila. So hindi natuloy yung bentahan ng lupa na to. Na in that case, yung favorable condition sana na mangyayari sa value ng lupa ni Z, hindi nangyari. Ngayon, pwede bang habulin ni Z etong mga parties na to? Hindi. Bakit? Kasi at the first place, wala namang stipulation sa kontrata ni X at ni SM na yung lupa ni Z mag-directly benefit. Di ba? Wala namang stipulation sa contract nila na may favorable conditions for Z. Wala eh. Nasadya lang na since adjoining lot to, may benefit. Di ba? pero hindi siya kasali sa usapan na magbe-benefit talaga to. So in that case, walang valid na stipulation for attorney. So yan na. Mahalagang ano yan eh. Kasi, bakit mahalaga? Mahalagang ma-distinguish yung stipulation for attorney. Kasi, yung third person, he can protect his right kapag valid niya na stipulation for attorney. He can protect his right. Kapag hindi yan valid yan, diba? Tapos umasa siya, diba? Umasa siya na may valid condition for him, yung si third person. Tapos yung pala, at the first place, hindi pala stipulation for attorney. Kawawa siya. He cannot defend properly his right. Wala siyang karapatan. So yan dapat maging valid yan. So let's go to 1312. Ito, di ba? Ito yung another exception sa third persons sa pwedeng umepal yung third person sa contract is in contracts creating real rights. (1312) provides that in contracts creating real rights, third persons who come into possession of the object of the contract are bound thereby subject to the provisions of the mortgage law and land registration laws. So basically, itong mga mortgage laws, mapapagdadaanan yun sa law on sales eh. Nandyan yan, si chattel mortgage, si condominiums, si recto law, si Maceda law, ito mortgage law, yan, nasa sales yan sila. So ano to? As we know, as we have said kanina, ano tong real rights? It is ang real right, as you have said, it is a right that you can assert that is enforceable, that is binding to the whole world. Meaning, kahit third persons, magiging binding yan sa kanilang real right. Diba? Kasi ang personal right, it is only binding between the parties. Pero ang real right, as you have said, it is enforceable against the whole world. You can assert it against the whole world. Third persons who come into possession of the object of a contract over which there is real right are bound thereby even if they were not parties to a contract. Bakit? Kasi as we have said, a real right is binding against the whole world and attaches the property over which it exercises wherever it goes. Ba? So, yan yung mga instances na kung saan kahit na hindi involved yung third party na yun sa contract. But since it is a real right, we're talking about a real right, binding yan sa third person. For example, buyer ka. Tapos ito si seller. Seller, binenta yung lupa sa'yo. Land. Yeah, land. Ngayon, etong land, ni-register mo sa Registry of Deeds or sa Property Registration Decree. Basta ni-registry mo siya. Na-registered siya. Registered. Ngayon, etong si S, binenta ulit yung lupa kay third party. Ngayon, in that case, since the land was registered at the first place, walang assertive right si third party over the property. Bakit? Kasi the mere fact that it was registered, the land sale was registered, means that it was already publicized to the whole world na may nangyaring sale. May nangyaring sale. Na kung saan, it basically means na nagkaroon na ng publication na, the moment that it was registered, nagkaroon na ng publication, meaning nabigyan na ng ang interpretation dyan is nabigyan na ng notification yung outside world, yung third parties, because it was registered. Bakit? Kasi pag bibili ka ng lupa, isa yan sa mga due diligence na kailangan mo gawin is pumunta ka sa Registry of Property, Registry of Deeds, titingnan mo kung sino yung totoong may-ari ng lupa. Titingnan mo kung due diligence tawag dyan, kapatid. The mere fact na ito sa registered, hindi mo pwede, hindi na valid defense. Hindi ko alam. Hindi. Sasabihin ng korte sa'yo, loko. Due diligence, dapat pumunta ka dun sa registry. Tingnan mo kung sino yung may-ari ng lupa. Tingnan mo kung may annotation. Hindi yan valid defense sa korte. dismiss agad yung petition mo. Dismiss agad yung kaso mo. Kasi nga, ang assumption, since registered na siya, so that is a valid notification to the whole world that na ini-inform lahat na nabenta yung lupa. Hence, may real right. Because that is a right that makes the whole world bind to that contract. Ngayon, yan yung yan yung deciding factor kapag na-register o hindi. Ngayon, pag hindi yan na-register, yun, may valid defense ka. Hindi mo pwede mo na sabihin na, hindi ako aware. But make sure good faith ka na, third party ka. Hindi ako aware na may nagkaroon ng bentahan kasi nung pumunta ako sa registry, wala namang nakalagay doon annotation sa titulo ng lupa na nagkaroon ng bentahan eh. Yun, valid defense yun. Kasi, hindi ni-register at the first place. So, wala kang assertive right against the whole world. Wala kang assertive real right against the whole world. So, yun, valid defense yun. So, in that case, mangyayari dyan, depende na sa labanan sa korte. Kasi, ito, additional note lang to kasi sa sales pa to sa madidiscuss. When it comes to the sale of immovable properties such as this one, the land, immovable property yan. Double sale, nagkaroon ng double sale. Ibig sabihin, binenta kay B, tapos din binenta pa sa third person. Nakadepende yan sa sino, may hierarchy yan kung sino yung pagbibigyan sa dalawang buyer. Meron yan yung unang hierarchy, sinong unang nakaregister in good faith. In this case, since in this case si B ang unang nakaregister, so wala nang valid defense si third party. Kasi ang assumption, since na-register na yan siya, na-inform ng whole world, and TP, since binding na sa real right na yan sa whole world, wala siyang valid defense. However, kahit na, on the other hand, kahit na nabenta kay B una, pero si TP ang unang nakaregister, yun, may panglaban si TP, siya ang unang nakaregister eh. Yun, mga ganong style ba? So, yun, kaya mahalaga yung notification, yung mag-register, mauna, i-register mo talaga yung property. Kasi, doon magbe-base yung pwede mong panglabang depensa sa korte. How will you defend your rights? So yan, additional note lang when it comes to real rights, it is binding to third parties. Basically, yun ang makuha nyo dito sa 1312. Real right, when properly done, binding to third parties. Wala silang magiging valid defense against you. Article 1313. Creditors are protected in cases of contract intended to defraud them. Di ba meron tayo na pag-usapan previously on Avatar? Di ba? Meron tayo na pag-usapan. Si D, may utang kay C, 1 million peso. Yan yung existing contract nila, may utang. On the other hand, nagkaroon itong si D, ayaw magbayad ng utang kay C. So, anong ginawa ni D? Yung remaining properties niya, dinonate niya sa kanyang pamangkin, which is the third party. Para in that case daw, ang inisip ni D, wais ako. Para hindi ako magbabayad ng utang ko kay C na 1 million peso, idodonate ko lang yung mga properties ko sa pamangkin ko para hindi ako mahabol ni creditor ko. Now in that case, anong nangyari? Si D, he tried to commit fraud against C by donating his property to his pamangkin para walang mahabol sa kanya si letter C. Para magsabi si D, insolvent ako, lang property pambayad sa'yo. Sabi ng batas, loko, hindi ganyan na mangyayari. Si C, in that case, anong pwede niyang gawin? Etong donation na ginawa ni D, pwede niyang ipa-cancel. Ipa-cancel. Para yung mga properties, bumalik sa kanya para si D may pambayad kay C. That is the essence of 1313. Creditors are protected of contracts intended to defraud them. In this case, that the contract that intends to defraud C, the creditor, is the donation made by D to his pamangkin, a third person in the contract. Because ang plano ni D is to not pay his obligation to C by making sure na wala siyang property na may papambayad kay C by donating his property to his pamangkin. In that case, 1313 makes, or sabi ng 1313, loko, hindi mo pwede gawin yan. Pwede yang atakihin ni creditor, pwede yang i-cancel ni creditor yung ginawa mong donation para ma-make sure ni creditor na babayaran mo yung Utang mo sa kanya. Utang na mo daw, sabi ni creditor. Yeah? So, yun si 13.13. 13.14, any third person who induces another to violate his contract shall be liable for damages to the other contracting party. Ito naman yung mga EPAL. Ito talagang EPAL talaga. Itong si buyer, seller, si seller may bibigay na lupa, si buyer bigay 1 million. Ngayon, itong si third party, diba, may kontrata na. Itong si third party, dinenggoy. Si B, sabi niya kay B, uy, wag mong bilhin ng lupa na yan. Balita ko, baka expropriate yan ng government, malulugi ka. O, baka exercise din ni government yung power of eminent domain niya. Baka malugi ka. O, baka kunin na siya ng government. Basically, tinatakot niya si B. Ngayon, itong si B, natakot sa ginawa ni third party. Sa pananakot na ginawa ng third party na baka malugi sa kanyang investment na lupa. So, ang sabi ni B, kay S, uy, cancel lang natin to. Sabi ni S, uy, bakit? Bakit may kakancel yung contract natin? Sabi kasi ni third party, baka daw expropriate ng government yung lupa na yan, yung subject land na bentahan natin. In that case, malulugi ako. Yun ang sabi ni B. Si S naman, saan mo nakuha yan? Walang plano dyan ng government na kunin yung lupa na yan in the future. So, sabi ni B, sabi ni third party, eto, si S, galit na galit. O yun, pwede niyang kasuhan si third party. O yun, ha? Kasi loko-loko si third party, EPAL. Dahil sa kanya, it caused damages to S. So, si S, pwede niyang habulin sa third party. 13.15. Contracts are perfected by mere consent. And from the moment, the parties are bound not only to the fulfillment of what has been expressly stipulated, but also to all the consequences which, according to their nature, may be keeping with good faith usage in law. And 13.16, real contracts as deposit, pledge, and commoditum are not perfected until the delivery of the subject of the obligation. So, ito ang pinag-usapan natin is what we have mentioned beforehand, yung according classification of contract according to perfection, dalawa. Consensual and real. Sa consensual, basically, the contract is perfected by mere consent. Sa real, it is perfected by the delivery of the object of the obligation. May pangatlo tayo dyan na tinatawag, yung solemn contract. Kung saan, it requires compliance with certain formalities prescribed by law, such as prescribed form being thereby an essential element thereof. Dito na papasok yung statute of frauds. Kasi sa statute of frauds, kung insertion sa internet, basically, pag-usapan natin ito late, beforehand pa lang, di ba? Recap lang ito sa statute of frauds. Dito sa statute of frauds kasi, may mga certain contracts kasi, certain obligations that requires formalities as provided by law. For example, a contract of lease that exceeds 1 year, kailangan kailangan nakasulat yan in writing. Yeah? O ito, contract of donation, in writing rin yan. Sale of yung mga sale that is more than 500 pesos, kailangan nakaresibo yan. Yung example yan ng mga contracts na kung saan kailangan merong formalities prescribed by law. Tingnan nyo yung statute of frauds, yung na-discuss natin. Yan yung pertain dyan. So yun, di ba? Una, consensual contracts perfected by mere consent. Real contracts perfected by the delivery of the thing that is the subject matter of the contract. And yung solemn contract requires compliance with certain formalities prescribed by law. Ngayon, let's talk about the stages in the life of a contract. 3 stage yan. Ito, take note of this, lalabas yan. Saan lalabas? Secret. Saan tayo dito? Stages in the life of a contract. 3 sila. Preparation or negotiation, perfection or birth, and pangatlo, consummation or termination. Ngayon, dito sa preparation or negotiation, from the term itself, dito nag-uusap-usap yung mga parties, ano yung mga pwedeng isaling stipulation sa kanilang contracts. Nagkakaroon basically, as stated here, negotiation. Ngayon, meron na silang definite agreement, di ba? Na ito yung babayaran nila, ito yung mga stipulations, ito yung subject matter ng contract, ito yung kailan babayaran, magkano yung interest, etc. Details that matters in the contract. Pagdating sa perfection or birth, ito na. This is when the parties have come to a definite agreement or meeting of minds regarding the subject matter and cause of the contract upon the concurrence of the essential elements thereof. So yun na. Sa preparation or negotiation, dyan sila nag-usap-usap ano yung mga stipulations sa contract nila. And the moment na nag-agree na sila sa lahat ng stipulations sa contract nila, dyan na may perfection or birth na, there's a meeting of minds na, basically. Ngayon, di ba sa contract meron silang obligations na kailangan gawin. The moment na nagawa na nila yung obligations nila, yun na, pupunta na sa consummation or termination of the contract. This is when the parties have performed their respective obligation. And the contract may be said to have been fully accomplished or executed, resulting in the extinguishment or termination thereof. So, di ba, first stage, preparation or negotiation, the parties talks, ano mga pwedeng stipulations is pasok nila sa contract nila. Perfection or birth. The parties have agreed na sa mga stipulations ng contract. May definite agreement na sila. Okay. Meeting of minds. Third, consummation termination. The parties have already performed their obligations, their respective obligations sa contracts. Okay, extinguish ng contract. Yeah? Simple. So, additional notes lang, how contracts are perfected, general rule. Ito. How contracts are perfected. General rule, consensual contracts perfected by mere consent. Ito sa real contracts, sa pag-usapan na ito. Solemn contracts, etc. Effects of the perfection of the contract. From the moment the parties come to an agreement on a definite subject matter and a valid consideration, they are bound not only to the fulfillment of what has been expressly stipulated, but also to all the consequences. Hirap, no? Ilonggo tayo dito. To all the consequences which according to their nature may be in keeping with good faith and usage of law. And lastly, sa discussion sa general provisions ng chapter 1 is Article 1317. Na itong Article 1317, basically, nasa yung topic na to, yung discussion dito, o yung essence niya, kumbaga, nasa voidable contract. So, last part na yun. But basahin lang natin. And konting discussion sa kanya. Kasi yung main essence talaga ni 1317, nasa voidable contracts. 1317 provides that no one may contract in the name of another without being authorized by the latter, or unless he has by law a right to represent him. A contract entered into in the name of another person by one who has no authority or legal representation, or one who has acted beyond his powers. Etong who has acted beyond his powers, typically this is the agent. The agent of the principal. Shall be enforceable or shall be unenforceable unless it is ratified expressly or impliedly by the person on whose behalf it has been executed before it is revoked by the contracting parties. So basically, the general rule is mawalan tayo ng boses dito. Basically, the general rule is a person not bound by the contract of another of which he has no knowledge to which he has not given his consent. Obviously. Bakit? Kontrata yan. Tapos bigla ka nilang isasama. Tapos wala kang kamalay-malay na sinama ka sa isang kontrata na hindi mo naman binigay yung consent mo. Or worse, hindi ka aware at the first place. Tapos bigla na lang ipapa-enforce sa'yo. Loko-loko sila. Di ba? Hindi mo binigay yung consent mo eh. Or worse, hindi mo alam na meron palang ganun. So, hindi yan enforceable sa'yo. So, hindi ka nila pwedeng pilitin. Goods lang yan. However, there are certain instances na kung saan, nung nalaman mo na ganun pala yung nangyayari, medyo nagustuhan mo yung stipulations ng contract. So, in that case, pwede mong ibigay later on yung consent mo in the form of ratification. Meaning, ni-ratify mo. Meaning, nagkaroon ka ng subsequent agreement to that. Na okay, since ganyan naman yan at the first place, sama niya na lang ako. Diba? For example, yung mga kaibigan mo, o yung isang mga kaibigan, bumili bulk tickets ng concert ng BTS. Diba? Bumili sila. Tapos, sinama ka nila sa listahan ng makaka-receive ng ng mga sinama ka nila sa listahan ng mga bumili ng concert ticket. So, which later on, sisingilin ka nila na, oy, bumili kami ng concert ticket. Sinama ka namin. So, sabi sa'yo, 20,000 peso to. Tapos nagulat ka, bumili ka ng concert ticket, hindi mo naman sinabi sa akin na bumili ka talaga para sa akin. Hindi ko yung babayaran, hindi ko binigay yung concert sa at the first place eh. Di ba? Pero later on, sinabi niya, para sa BTS to, tanga. So sabi, ikaw, fan ka ng BTS. Okay, bilhin mo. So yun, in that case, nagkaroon ng ratification on your part, di ba? Kasi bumili sila ng concert ticket, sinama ka nila sa mga binilhan nila, kahit na hindi mo naman sinabi o binigay yung concert mo the first place, first hindi ka aware na ginawa nila yon, hindi ka nilang pwedeng pilitin. Pero nung nalaman mong pang BTS pala yung concert ticket na binili nila, kahit 20,000, 30,000, 40,000 pesos pa yan, since fan ka ng BTS, tinanggap mo na lang. Binayaran mo na lang sila para sa concert ticket na yan. In that case, nagkaroon ng ratification. Yun. So, unauthorized contracts can be cured only by ratification, may time lapse. So, yun ang discussion natin. Pero kasi itong voidable and enforceable contracts, sa last part yan. Sa tawag doon? Anong term yung ginamit ng, kalimutan. Yung sa kinds of defective contracts yan. Yan. Kung magkakaroon man ng question sa board exam in relation to contracts, for sure dyan yung kukunin. Sa defective contracts, sa voidable, voidable, rescissible, and enforceable. Kasi in those contracts kasi, analyzation talaga. And maganda rin yung discussion sa kanila eh. Yun yung, for me, isa yun sa mga very useful discussion sa law on obligations and contracts. Kasi magagamit mo talaga sa in real life. Nasabi mo, yung contract na yun, void yan hindi yan valid. Ang contract na yan, okay, voidable yan. Yung contract nga, you cannot enforce that contract, that is unenforceable. Okay, we can resist, resistable ang contract na yun, applicable sa real life, promise. So in that case, but last part ng discussion natin, kasi last part siya ng book, yung articles niya, which is before the natural obligations. So Sunday, I will be posting the chapter 2, essential requisites of contract. Sunday ko na ipopost yun. So ito, chapter 1, general provisions, basically, introduction lang siya. With that, good night na. Bye-bye. Love you.